Today we explain the requirement of intention to create legal relations in contract formation. Courts assess this objectively, looking at the parties' words, conduct, circumstances, and relationship, not their subjective thoughts. The leading case is RTS Flexible Systems Limited versus Molkerai, Alois Müller, GmbH & Co. KG, 2010, 1 WLR 753, which confirms that even if some terms remain unfinalized, the overall facts may show a binding agreement. Courts distinguish sharply between domestic/social agreements and commercial ones. In domestic and social agreements, there is a rebuttable presumption against legal intention. For husband and wife living together in harmony, agreements are presumed unenforceable. In Balfour v. Balfour, 1919, 2 KB 571, a husband promised his wife £30 monthly maintenance while posted abroad. When he later refused, the Court of Appeal held it was a domestic arrangement not intended to be legally binding. The presumption weakens if parties are separated. In Merritt v. Merritt, 1971, WLR 1211, a separated husband's written promise to transfer the house if wife paid the mortgage was enforceable because the context rebutted the presumption. For parents and children, the same presumption applies. In Jones v. Padavatten, 1969, 2 All ER 616, a mother's arrangement to All ER 616, a mother's arrangement to provide a house for her daughter studying law, was not legally binding. The daughter could not rebut the presumption while relations were good. In social agreements between non-relatives, presumption is also against. In Lees v. Devonshire Club, 1914, The Times 4th December, a golf club prize winner could not enforce it. No one intended legal results. But in Simpkins v. Pays, 1955, 1 WLR 975, a joint newspaper competition entered by family and lodger was binding as a shared enterprise with clear reliance. In commercial agreements, there is a strong presumption in favor of legal intention. The burden to rebut is heavy. In Edwards v. Skyways, 1964, 1 WLR 349, an airline's ex gratia golden handshake promised to a pilot was enforceable. The employer could not show lack of intent. The presumption can be rebutted by express exclusion. Letters of intent often do not bind. In British Steel v. Cleveland Bridge, 1981, 24 BLR 94, steel supplied under a letter of intent led only to a reasonable payment obligation, not a full contract. Letters of comfort create only moral responsibility. In Kleinvort Benson Limited versus Malaysia Mining Corporation, BHD*, 1989. 1 All ER 785, a holding company's statement of policy to support its subsidiaries' debts was not legally binding. Honor clauses also rebut intent. In Rose and Frank Company versus Crompton Brothers Limited, 1925, AC 445, an agreement with an honor clause stating it was not a formal legal agreement was unenforceable. Promotional offers can show intent. In Esso Petroleum Limited versus Commissioners of Customs and Excise, 1976, 1 All ER 117, free World Cup coins given with petrol created a collateral unilateral contract with legal intent. Mere puffs are generally not binding. See Carlyle versus Carbolic Smokeball Company, while collective agreements between unions and employers are presumed non-binding unless expressly stated otherwise. Ford Motor Company, Limited v. AUEFW, 1969, 2 QB 303, reinforced by statute. Finally, an agreement to agree is usually unenforceable due to uncertainty, as in Walford v. Miles, 1992, 2 AC 128. This objective assessment ensures only serious agreements become contracts. Flashcards front. What is the objective test for intention to create legal relations? Leading case? Back. Courts look at words, conduct, circumstances, and relationship objectively. RTS, Flexible Systems Limited versus Molkerai, Alois Mueller, GmbH & Co. KG, 2010. 1W LR 753. Front, presumption in domestic/social agreements. Husband-wife example? Back, presumption against legal relations. Balfour versus Balfour, 1919. 2. KB 571. Maintenance promise not binding. Rebutted if separated. Merritt versus Merritt, 1970. 1. WLR 1211. Front, parent-child and social non-relative cases. Back, Jones versus Padavatten, 1969. 2 All ER 616. House for Studies, not binding. Simpkins v. Pace, 1955. 1 WLR 975. Joint competition, binding due to reliance. Front, presumption in commercial agreements. Key rebuttal case. Back, strong presumption in favor. Edwards versus Skyways, 1964. 1 WLR 349. Ex gratia payment binding. Front, effective letters of intent, comfort letters, honor clauses. Cases. Back, usually no binding intent. British Steel versus Cleveland Bridge, 1981. 24 BLR 94. Kleinvort Benson Limited versus Malaysia Mining Corporation Berhad, 1989. 1 All ER 785. Rose and Frank Company versus Crompton Brothers Limited, 1925, AC 445.